Good morning, Mr. Hurley.
Good morning, Your Honors. I'm here this morning on behalf of several of the owners of the Phase 2, second phase of the Cape Cod condominium in Falmouth, Massachusetts. The issue that's before the court, and one that I feel has great public policy implications, is whether or not a declarant, as was the case before you, can
Excuse me, were your clients aware of the provisions about the allocation of costs and the voting rights when they bought their properties?
Well, Judge Piper seemed to think they were, but I would
They
suggest
could have been aware, right? Everything was recorded.
they were aware of what was in the public record.
Okay,
That's
so
for sure.
why isn't there a waiver here?
Well, I have two answers to that. The first is, I'll come back to, but the first is, I don't think there can be a waiver of this particular statute. But directly to answer your point, Your Honor, if you really look carefully at the documents that are in the public record and the record before the court, the only evidence that would support an inference of their being aware of this purported waiver of the statute is what's in the public record. There's nothing else before you. If you look carefully at the documents, you'll see three. You'll see an amendment to the master deed, you'll see an amendment to the condominium trust document, and you'll see an extension of the development rights that was entered into pursuant to the settlement agreement. The master deed amendment does not say anything like there's been a reallocation and explain how that reallocation was done.
It does say that the Phase 2 owners will have 68 point whatever % of the ownership.
If you do the addition, it does. I mean, it doesn't specifically say that. You have to look at the Schedule B, you have to add it up, and you have to indulge in the assumption that a unit purchaser who did that would say to himself or herself, wow, this doesn't comply with the statute, because how would they know that when they purchased their unit? How would the unit owner know that the relationship between the value of a new unit, a unit that's built 10 years later, was disproportionate to the value of the entirety of the condo with the two phases?
Is a roof a common area?
Is a roof a common area?
Yeah.
A recent appeals court decision in Lalo versus Sabo, which was not cited in the brief because it was just decided in August, would suggest that it is, and I think it is under the condo documents as well.
So I suppose theoretically in this case, the Unit 1 owners could have negotiated with the builder a change in the master deed such that the Phase 2 unit owners would pay 100% of all the common area costs. I mean, that's possible under the theory.
Attributable to the second phase.
Yeah.
Right.
Well, they did. That's what the settlement agreement says.
Well, it's not 100%. I mean, the management fee is still 50%.
The management fee is split 50-50, yes. But in terms of the common areas that are attributable only to Phase 2, the agreement also said that they would pay 100%.
And I think Justice Spina's may be saying that even the roof on the
Unit Phase 1.
Right.
They could have negotiated that too.
They could have negotiated anything with the declarant, Your Honor. I mean, the declarant was in a position where he didn't really care about what happened to the Phase 2 owners. He would have agreed to anything as long as it would get him to go forward with his second phase. But the question is, can you do that under 1A35A, and I would suggest to the court that you can't. Now, to my knowledge, this is the first time that 5A has come before this court. 5B has come before this court frequently.
Let me ask you this question, though, about 5A, and then
Sure.
I have another one. 5A reads something like it's got to be, equal value at the time of the master deed, right?
That's right.
So how do we know that when your clients or when the amended master deed was recorded, which was in 1999 or 2000, right?
99.
99. How do we know that the value that came out in 2003, which is, I think, that's what sort of must have brought you to the courts?
Correct.
How do we know that value was the same in 2000?
Well, we wouldn't until somebody makes a factual determination on that point, Your Honor. I mean, that's part of the difficulty of that statute. There's no question that 5A is a difficult statute to sort of...
So wouldn't that support the idea that maybe it isn't so that nobody can negotiate a change to it?
I don't think so, Your Honor. The fact that it may be difficult to calculate, I don't think countermands what I think is a clear legislative intent that however difficult it may be to do it, that at a point in time, you have to allocate the percentage interest in that ratio that they've established. Now,
How is it typically done? Is there usually a fair market value determination when a second phase is built, or is a determination made based solely upon the ratio of square footage?
Your Honor, I believe as a practical matter, it's done in the latter way. I don't think that it's done typically through an appraisal process. But typically, you don't have this sort of odd agreement, and I don't think there's been a great many disputes if it's done on that square foot basis. In fact, one of the cases you recall that came before this court was the Pone-Lydell case, and it was a land court decision that employed a slightly different methodology, perhaps than had been contemplated by the statute. It did square foot plus methodology, and the court didn't disturb that. So I think this court has recognized, and certainly trial courts have recognized, that there's difficulty if you actually get to the point where you're being sort of challenged to figure out what that value was at a particular point in time.
But if it's square footage, is it about 50-50? I don't remember. Between phase 1 and phase 2?
If it's square, I'm not sure of the answer to that.
But I mean, I guess my point is, assume it is close to that.
Right.
Doesn't that support the waiver idea? Because they knew that collectively this 50%, they see this 68-31, and they buy anyway.
But that presumes that they're
You can waive.
that they're going to indulge in that sort of calculation.
But they're buying, they're making a big investment. Don't they have to be held responsible to do some sort of investigation?
But Judge, as a practical matter, you're down the Cape.
Mr. Hurley, forgive me for interrupting. I have the land court judge's decision on this, saying that they were fully on notice.
Your Honor, but he based that exclusively on the 3 documents that I've just referred to.
Yes.
To you. There's nothing in the record other than that. And if you look carefully at those documents, I would suggest to the court that if that was a finding that he made, and in fact the way he put it was, at one point in his decision, he said, there's nothing in the record that would support an inference that the owners didn't know, which I would suggest to the court was a implicit burden shifting on the issue of waiver.
But your argument is that it's void, isn't it?
My argument is that it's void, and that you don't need to get to the issue of waiver.
Well, you were about to say you're down at the Cape,
You're down
and
the
you're
Cape,
looking at the
you're
property.
looking at the place. You
and-
see, you have a
And
brand
you don't
new.
have any duty to read the document?
You definitely do have a duty to read the documents, Your Honor.
Caveat
And
emptor,
in that
wasn't
regard,
that-
to be candid, I would make a distinction in this case between the 5A waiver argument and the 10A waiver argument.
So how is this fair to the people in the phase 1 portion of the development who they were holding the cards in their hand, and they could have stopped the development altogether, and yet a deal was struck?
I agree.
So they lose out.
I think they do lose out. I think they
Do they
necessarily
lose,
lose
do
out.
they
but-
lose out, or does the developer lose out? Because they don't lose out. They have their nice condos there, and they've got nobody else around. Correct?
I'm sorry, how do they lose out?
Well, the
Judge,
phase 1, they wanted to.
I agree that there is a scenario. I don't really know what the circumstances were back in 1989, 1990, as it related to the phase 1 owners. Clearly,
But there was no phase 2.
they clearly had the power if they chose to exercise it, leaving aside some other issues about tolling. They had the power to stop phase 2 from being built.
Well, no, they didn't. They only had the power to stop phase 2 if phase 2 was going to be different than it was in the original documents.
Well, they also took the position in a litigation, Judge, that the time had expired, essentially. And so they had litigation positions. Whether they were good or bad, I'm not sure.
But Stewborn, it appears from the record, Stewborn was not interested in building a 47-unit.
He absolutely was not.
So-
Because I assume the economics were such that
Yeah.
that didn't make sense anymore. And so, but they did not agree that he could build a 47 either. I mean, that's clear.
But that's sort of
So-
theoretical, because he never wanted to.
I understand, but he really presented 2 options to them. I'll build a 47 because I have a right to do that, or I'll build 20 if you'll agree that I can
All
do that.
that doesn't matter, though. I mean, that's just water over the dam, because what was negotiated was negotiated. And I mean, what was
But, Your Honor, I, and just in response to your question, Justice Spina, Yes. Is it possible that that the first Phase 1 unit owners wouldn't get the benefit of their bargain if you were to determine that you can't waive the protections and the requirements of Section 5A? The answer is yes, of course. That's the situation. But the issue is, does this court want to set a precedent that says that by virtue of a private agreement that you can essentially alter or amend a clear directive in the statute?
But if it's waivable, your clients, it seems to me, lose because they were on notice that this had happened before they bought. The question that it seems to me your better argument is that it was, I don't know if it's your better argument, your alternative argument is that it's void.
Absolutely. That's you don't need to get to the complexities of the waiver issue.
Mr. Hurley, what are the implications of that? That whenever there's a dispute between a developer and the condominium unit owners, and it's in court, and they reach a settlement agreement, and it doesn't comply precisely with Section 5A, and Section 5A is a lengthy statute. It has many, many things, including ownership shares, that settlement agreement is void?
That provision in the settlement agreement is void, Judge. And 5B has lengthy provisions, particularly since the 98 Amendment, but 5A is pretty simple, and I think it's just a couple of sentences.
I'm sorry.
It just says, you will, you shall, in clear and unambiguous words, you shall establish this ratio. Now, what the methodology you use to get there, that can be subject to interpretation, but the premise of the statute is that you will establish this ratio. Now, on 5B cases, the court has repeatedly held that you can't tinker with that by virtue of a private agreement. There's just no question. The court has repeatedly said that you can't do that. Now, there's a distinction that is attempted to be made on the one hand that says, well, 5B implicates public policy issues, but 5A does not. And I don't see how you can read that from the statute.
This is something that confused me. It appears that part of the, I think it's the master deed, says anything in the master deed that conflicts with Chapter 183A, 183A controls,
That's
right?
correct.
You don't seem to make much of that. Why not?
Well, I mean, we mentioned it, certainly.
You
in the
mentioned it,
brief.
but I mean, it would seem to me it's sort of key, isn't it?
I think it is key, and if we didn't emphasize it enough, shame on me. There's at least 3 places in the master deed that you could point to: paragraph 7, paragraph 9, paragraph 14.
But the judge didn't mention that at all.
Didn't mention it at all. But they say, in effect, and this is my words, not the precise words of the document, but they, in effect, say any 183 controls, and we're doing everything in accordance in 183, and to the extent that there's anything in these documents that's inconsistent with 183A, it's no good. Clearly, that's what the master deed says. And
You mentioned it in a footnote. I mean, it just seems to me that's your strongest argument, isn't it?
I think.
I mean,
the strongest,
I feel like I'm
I
missing
think the
something.
strongest argument, relying on the cases that have interpreted 5B, is that 5A is not a waivable provision.
And is that the Strauss? Is that
That's the Strauss decision. That's the 5B case. And in that case, I mean, if there was ever a waiver case, the Strauss case presented it to this court. I mean, in that case, everybody knew that people had the ability to build out into common areas. People built out into common areas. People knew about it, condoned it, and then at some point a new person comes along and buys a unit and says, oh, you can't do this. This violates the statute. And this court said specifically, notwithstanding that course of conduct, that you cannot get around a statutory mandate under a doctrine of waiver.
Mr.
Full
Hurley,
stop.
could you address the 5B23, you know, the fair and equitable under the circumstances? I mean,
I
isn't
will,
that...
Your Honor. And let me start by saying how the court handled that, the trial court handled that. Judge Piper just didn't address it.
I know that.
He was aware of the Northland case from the First Circuit,
Yeah.
and he said, I don't think this statute applies here because this was not the unit owner association that was doing this allocation. It was, in effect, the developer that was doing it, and so I don't think the statute applies. And as a consequence, because he didn't think the provision applied, he didn't even purport to make a finding as to whether this would have been a fair and reasonable allocation allocation. And in fact, I mean, in fairness to the judge, he assumed for the purposes of his analysis that there was this he assumed a violation of 5A. He didn't necessarily, he didn't find that, but he assumed it for the purposes of the summary judgment motion. And so if you were to agree here that you can't revise 5A, that you can't amend it effectively by agreement, we wouldn't have to deal with any of those issues. If you were to say that it's a waivable issue, I would suggest to the court that the case would need to be remanded to see whether it was in fact waived, because I don't think that based on the record before this court, there was any basis for the court to find or infer that there was such a waiver. And then at that time, we could address some of these more difficult issues. But the fundamental position that we assert in this case is that 5A is not waivable, and you need not trouble yourself with the more difficult factual issue of whether there was in fact a waiver. Thank
Justice
you.
Gans?
If I could, what is the implication of your view of the law that's not waivable? Let's assume that you prevail here and that it's 50-50, and let's assume that one of the unit owners in Phase B builds a Taj Mahal, so that the fair market value of Phase B now is considerably greater than Phase 1.
I mean, if that happened going forward?
Yeah. Would you, it says fair value, it's not waivable. Would there be a requirement to be revising the allocation because it's non-waivable and mandatory and statutorily
I
required?
think the answer to that, Judge, is that you can't do that. You can't build a Taj Mahal because there's limitations on what you could do. I mean, you're stuck.
You can still renovate your unit, and the fair value of your unit can be considerably greater. There's no reason that the fair value may not vary.
It's
I mean, yes,
possible,
you could
but
not build a Taj Mahal on the outside, but you could certainly
you
do
could put
things
better, you
within
could put
renovations.
better refrigerators and sinks, maybe, depending
How
on what the-
about gold
Whirlpools.
plated?
I suppose you could do that. So the question
Circular
is, would you,
staircases.
if you had that fair value, if it
We've
went
had
up?
some recent condominium buildings here where
I think you'd have to look to the language of the statute. Again, rightly or wrongly, what it says is that you do the measuring as of the date of the recording of the master deed, or presumably at the date of the recording of amendment to the master deed. So the statute really doesn't contemplate sort of an ongoing annual reassessment of what the individual values of the units are. That would be a very difficult statute if that were the case. The Massachusetts legislature has dealt with issues largely in response to decisions from this court by amending the statute. If the legislature thinks that 5A is unworkable or unfair, I suggest to the court it's a legislative matter to deal with that. But as it's presently written, it should not be waivable.
Thank you, Mr. Hurley. Good morning, Mr. Angelini.
Good morning. Michael Angelini for the appellees. Your Honor, I'd like to first bring to your attention the issue of notice. It is not necessary from the recorded documents, and as we all know, we live in a commonwealth by which the recording statute provides notice, constructive notice of events in the chain of title. There are documents which explicitly set forth, recorded documents set forth at the time of the settlement agreement or within a short time thereafter, and before any of these Phase 2 unit owners purchased any of their units, documents which explicitly state, and I refer your attention, first of all, to the document in the appendix at page 147 and 148. It's the Certificate of Amendment to the Declaration of Trust. It was recorded on May 17, 2000. It's set forth. I won't bother repeating it. It says on page 2 of that document explicitly that the percentage allocation is 31.41% in the aggregate to the owners of the first 20 units and 68.59% in the aggregate to the units of the second new building. There is no need to make a calculation. All of the other terms of that settlement agreement are likewise set forth in that declaration. And
but what about the term in the master deed that says that if there is a conflict between this and Chapter 183A, provisions of Chapter 183A will control?
I'm happy to address that. I don't believe there's any there is even one violation or conflict between Chapter 183A and this provision. Looking at the statute, Your Honor, and it requires a fair reading. The statute says, as someone pointed out, I think Justice Botsford pointed out, it requires in Section 5A a relationship, a fair value relationship of the units on the date of the master deed. And indeed, there is no assertion here whatsoever that on the date of the master deed,
Well, it
which
would
was
be the amended master deed.
no, it says on the date of the master deed. And the legislature, well, with all
You've got to, I mean, if in a phased development, don't you have to read that?
well,
It's amended
you,
master deed.
you do, except that there was a phased development here, and the phased development, as Your Honor, I think, indicated, anticipated the development of 47 units in Phase 2. That was anticipated, and the values purportedly were arrived at in anticipation of what was set forth in the master deed. Now, the legislature knew the difference between a master deed and an amendment to the master deed, because 4 or 5 lines below that in the statute, it says something which the appellant is asking this court to force a violation of. It says that the percentage of the undivided interest of each owner, as expressed in the master deed, shall not be altered without the consent of all unit owners whose percentage would be materially affected. And then it goes on to say, as expressed in an amendment to the master deed. So the legislature recognized that there may be circumstances by which the master deed may be amended, but it explicitly provided that that could not happen to the detriment of, in this case, the first phase owners without their unanimous consent, and there is no unanimous consent here. So essentially what the appellants are asking this court to do is to overlook the fact that they had full notice of this when they bought their units. I suggest to you that you don't have to read Professor Samuelson's book to recognize that that had an economic impact on the value of these units. Obviously,
Is there any evidence in the record that that's true?
there is no evidence of the record. The trial court referred to it.
Well, I know, but it's an assumption, but we really don't know anything about it.
Well, we don't know anything about it, but I think we all know, as a matter of just common sense, that if you buy a piece of property which is settled with some expense as compared to buying the same piece of property settled with lesser expense, the first piece of property is worth less than the second piece of property. This is I won't cite myself for that.
Probably don't require a Lanigan hearing on that.
I do not think you do, Your Honor. I do not think you do.
But I guess my only point is that if you accept the idea that the Phase 2 owners didn't recognize all the permutations and computations, didn't realize all the implications of the settlement, it's not necessarily the case that the purchase price reflected those things.
Well, you would have to assume that they were deaf, dumb, blind, ignorant, and not represented by counsel, as all of them perhaps were. It is there. It is in the statute. It is explicit, in the recorded documents. It's explicit. Indeed, the amendment to the master deed, which is recorded in the chain of title, not only sets forth the compendium of common area obligations, the 68.41% and the other, it sets forth in the amendment to the master deed, which is in the appendix at page 134, it sets forth for each unit of the second phase, the specific percentage allocation. So a person buying a particular unit would obtain a certificate of title, and his or her certificate of title would indicate that that title comes from an amended master deed, and it specifically says that if you're buying unit B5, your percentage of the common area expense is 4.69%. You have a living room, a dining room, a kitchen, a master bath, et cetera, and 2 bedrooms, and it tells you exactly what you're going to pay. It is difficult to accept the fact that in this situation, what they are asking us to do is to overlook that fact and to force you to violate the rights of the Phase 1 owners, who, when they bought their Phase 1 units, bought so on the reasonable expectation, as set forth in the master deed, that they would pay 31 point something or other expense.
But also hidden in here, they bought on the reasonable expectation that there would be no building on the, whatever that front common area facing the ocean is, correct? I mean, that's what...
Well, they bought it, I think, with the expectation that if there was a building, it would be the building that was set forth. When they agreed, excuse me, I'm sorry.
The 47-unit building was going to be built right there, wasn't it?
It was going to be built in the same place the other unit was. But as the record is clear, as my brother suggests in his papers, if not in his argument, when they reached this settlement, because the original owner had foregone his right to build those 47 units, because he wanted a different plan, and because this matter was in litigation, and there's been no assertion here that that litigation was brought in bad faith, and certainly nothing in the record to support such an assertion if it was made, If they had not settled this with Stewborn, if they had simply, they would own that property, according to the law, as tenants in common. They would own that vacant piece of property. Now, admittedly, they would pay then all of the common area expenses attributable to all of the property, but I suggest to you they had the power, and they gave that up. They negotiated it with someone who exactly is in the chain of title of the people here who are now complaining. And to add to the foolishness of this all, in this case, Stewborn, the developer who was able to build these properties and presumably profit from doing so, has intervened in this case and has asked the trial court to grant him relief from the common area charges he had in that period of time before he was able to sell it to the 20 people who bought it with notice of this settlement.
Mr. Angelini, can you
Yes.
help me out with the location of the building of Phase 2? Is the current building in the place that was anticipated by the original design of the project?
At least in rough measure, I believe that's correct.
And it's
Joe.
about half the size of the contemplated building?
I don't believe it is half the size of the contemplated building, but there are 20 units. I think there are 20 significantly larger units than the 47 that were anticipated before.
So the outside shell is about the same.
The outside shell is smaller, but not half. That's
And
my
what
underst-
does-
that's my understanding, Your Honor.
What does this second phase building do to the beachfront? Because there's discussion of beachfront, but then nothing ever tells us what eventually happened as far as beachfront or ocean
Well,
view.
I think both of the, I've seen these from the water. Both of these, all except for the Cuddy Hunk units, and I think there are 6 of them. The 14 of the 20 units in the first phase and all of the units in the second phase face Buzzards Bay. Whether it's beachfront or rocky front, I'm not sure, but they face the water and have grand views.
Mr. Angelini,
Yes, Your Honor.
if in fact there hadn't been a settlement here, and as you say, the unit or the Phase 1 owners would own the land in
Yes.
common, could they then have granted new development rights?
I believe they could, Your Honor, and I believe they could grant those new development rights by reason of the statute that was in place at the time this occurred, and that's in Section 183 B 3 triple I. And indeed, there are at least 3 paths by which this court can analyze this problem. One is the path taken by Judge Piper, which essentially says there is no public policy which ought to stand in the way of the sustained public policy of this court and the Commonwealth, which says that if there is litigation, and that litigation is settled by commercially sophisticated people with the assistance of counsel, and it results in the dismissal of that litigation, that unless there is an overriding public policy, it should be honored.
Well, what about the idea that, let's say, a meteorite falls through the roof of a building in Phase 1? Why should the people in Phase 2 have to pay 2/3 of the cost of fixing that roof?
Because they made a deal. They reached an agreement. I mean,
So
I'm
it
party to
could've-
many agreements which in retrospect are not necessarily fair, but they were fair when they were made. They were made openly. They were made with commercial reasonableness. The law is full of the commercial code. The Uniform Commercial Code is full of standards which people agree to change. It turns out sometimes they make good deals. Sometimes they make deals which in retrospect they don't think are so good. But that happens every day in our country, Your Honor. That is the nature of what we do. It is the nature of negotiation. It is the nature of compromise. It's the nature of settlement. And it's something which this court promotes.
And there would probably be insurance and special assessments and lots of other things of a meteor.
No fact is a fact in vacuum. I mean, there are a variety of them, and I can't imagine them all. But
It strikes me, though, that there's been a lot of discussion in the briefs about whether or not this was a financial consideration. But what if we look at the legislative scheme of this and not look at it so much as a financial scheme, but as a matter of community governance? Sure. How can these people live peaceably side by side, where one of the groups is paying 2/3 of the cost of the repairs to the other person's house?
because they agreed to do it.
They didn't agree to that.
They did agree to it, Your Honor. As a matter of law, they did agree to it. They bought this property on the understanding that that controlled their purchase. They absolutely did agree to it, I believe. Their predecessor in title made that arrangement. They bought their properties with that arrangement in place. I suggest to you it had an economic impact on those properties, but that's not before you.
But wasn't the legislature concerned about how these people are going to live side by side? Isn't that why it said we're going to have a percentage of your...
I don't think there's anything in the statute to suggest that. I think the statute was an enabling statute. It set forth a framework, and like many statutes which set forth a framework, it set forth a framework which at least sophisticated people could contract around, and they did. But for this settlement, these Phase 2 owners would not have a view of Buzzards Bay, at least not from this location. But for this settlement, this Phase 2 would not exist.
They could come to your property.
They could, Your Honor. They could. They wouldn't have as good a view,
Mr.
however.
Angelini, so far you've got me through Path 1, which was
Yes,
Judge
Path 2 says, let's look at the fact that you cannot do what they want you to do because you would violate the rights of the Phase 1 owners. Path 2 says you cannot do this because by statute, explicitly, you cannot have a variation in the common area interest without the unanimous approval of the Phase 1 owners, and that is not the place here.
Okay.
And Path 3,
yeah.
and Path 3 is the statute. Path 3 is a statute in 183, Section 5B, III, which says very explicitly that the Board of Trustees can extend, revive, or grant rights to develop a condominium. And they can do so on terms as conditions as they deem appropriate. And they can, in doing so, include a method or formula by which the percent of interest of each unit is to be set forth. In Section A in subsection A of Section 5, or in accordance with another method which they, the organization of unit owners, reasonably determine is fair and equitable. The statute does not say, by the way, it must be reasonably equitable. That must be fair and equitable. It simply says that there must be factors in place by which they reasonably determine it is fair and equitable. And what could be fairer? What could be more equitable than to say we will not force a violation or do something which would violate the rights of the unit of the Phase 1 owners. We will not diminish their common or affect their common area interests. We will maintain what was set forth in the master deed, and that's all they did. There is no change in the percentage interests here from what those percentage interests are set forth in the master deed. Beyond that, I do want to emphasize that there is no supposition here with the issue of notice. There has not been advanced, in addition to that, not one sound public policy reason why the substantial public policy of confirming settlement agreements in litigated matters should be disregarded by this Court. We have not heard one, and there is not one, I suggest. Thank you.
Thank you, Mr. Angelini.